The progress of the case law throughout history must be cautious. The decision is not between stability or change. It is a question of speed of change. The decision is not between rigidity or flexibility. It is a question of the degree of flexibility. The judge must take into account a complex array of considerations. A judge must consider the coherence of the system in which he or she operates, the powers and limitations of the judiciary as an institution, as defined within the system, and the way in which his or her role is perceived. The second role of a judge in a democracy is to protect the Constitution and democracy itself. Indeed, if we wish to preserve democracy, we cannot take its existence for granted. We must fight for it. This is certainly the case for new democracies, but it is also true of old and well-established ones. The assumption that it cannot happen to us can no longer be accepted. Anything can happen. If democracy was perverted and destroyed in Germany of Kant, Beethoven, and Goethe, it can happen anywhere. If we do not protect democracy, democracy will not protect us. I don't know whether the judges in Germany could have prevented Hitler from coming to power in the 30s. But I do know that the lesson of the Holocaust and the Second World War is the need to enact democratic constitutions and ensure that they are put into effect by judges whose main task is to protect democracy. It was this awareness that, in the post-World War II era, helped promote the idea of judicial review of legislative action and made human rights central. It led to the recognition of defensive democracy and even militant democracy. And it shaped my belief that the main role of a judge in a democracy is to maintain and protect the Constitution and democracy. Democracy is a rich and complex normative concept. It rests on two bases. The first is the sovereignty of the people. This sovereignty is exercised in free elections held on a regular basis in which the people choose their representatives, who in turn represent their views. This aspect of democracy is manifested in majority rule and in the centrality of the legislative body through which the people representatives act. This is the formal aspect of democracy. The second aspect of democracy is reflected in the rule of values, other than the value of majority rule, which characterizes democracy. The most important of these are separation of powers, the rule of law, judicial independence, human rights, and basic principles which reflect yet other values, such as morality, justice, public peace, security, reasonableness, proportionality, good faith. This aspect of democracy is the rule of democratic values. It is a substantive aspect of democracy. The world of democracy is rich. Democracy should not be viewed from one-dimensional vantage point. Democracy is a multidimensional. It is based both on the power of the majority and on the rights of the individual. Indeed, democracy is based on a very individual's enjoyment of rights of which even the majority cannot deny him, simply because the power of the majority is in its hands. Democracy has its own internal morality, without which the regime is no longer a democratic one. Democracy, then, is based on simultaneous existence, both of the rule of majority and the rule of values, which characterizes democracy. A delicate balance must be kept between the two aspects of democracy in a way that protects the nucleus of each of those aspects. This balance will be based inherently upon the restriction placed both on a majority rule and on the rule of fundamental values of democracy. The realization of those two roles by the judge requires that judges will act objectively. The objectivity required of a judge is difficult to attain. Even when we look at ourselves from the outside, we do so with our own eyes. Nevertheless, my judicial experience tells me that objectivity is possible. A judge does not operate in a vacuum. A judge is part of society, and society influences the judge. The judge is influenced by the intellectual movements and the legal thinking that prevail. A judge is always part of the people. It may be true that the judge sometimes sits in an ivory tower, though my ivory tower is located in the hills of Jerusalem and not on Mount Olympus in Greece. The judge progresses with the history of the people. All of these elements contribute to the judge's objective perspective. When judges give expression to the fundamental values of the system, they give expression to the values that, in their eyes, seem proper and basic. Some subjectification of this process is inevitable. Complete objectivity is unattainable. The personal aspect of the judge is always present, and his or her life experience neither disappears nor can disappear. Rosie, you were right. We would not want it to, because in this situation, it is the judge personality that finds expression, the same personality that underwent and passed the judicial nomination process. We need not, however, go from extreme to extreme. Rejecting complete objectivity does not require us to embrace complete subjectivity. There is a third way, reflected in acknowledging the importance of the centrality of judicial objectivity, while recognizing unreservedly that it can never fully be achieved. It is enough for a judge to make an honest attempt to objectify his or her exercise of discretion, recognizing that it cannot be done in every case. As a rule, I have always tried to carry out my role as a judge within the framework of social consensus to the extent that data exists about it. The judge should generally not be a crusader of a new social consensus. As a rule, judges should reflect values and principles that exist in their system rather than create them. Nevertheless, there are cases, and they must naturally be few, in which the judge carries out his role properly by ignoring the prevailing social consensus and becoming the flag bearer of a new social consensus. Consider Brown versus Board of Education, which was just mentioned. I don't know what the consensus was in the United States just before the Supreme Court decision in Brown, but the court at that time fulfilled its role even if it ruled against the then prevailing consensus. Naturally, a court will not retain public confidence if it announces a new Brown twice a week. Similarly, a court will lose public confidence if it misses an opportunity like Brown when it is faced with it. In the final analysis, everything is a question of degree. The consensus with which judges usually ought to operate should be a consensus grounded in the fundamental values of the legal system. Judges should not act according to the consensus formed by transient trends that are inconsistent with the society's fundamental values. Judges' social framework must be central and basic, not temporary and fleeting. When society is not being true to itself, judges are not required to give expression to its passing trends. They must stand firm against these trends while giving expression to the social consensus that reflects their society's fundamental principles and tenets. An essential condition for realizing the judicial role is public confidence in the judge. This means confidence in judicial independence, fairness, and impartiality. It means public confidence in the ethical standard of the judge. It means public confidence that judges are not interested parties to the legal struggle and that they are not fighting for their own power, but to protect the Constitution and democracy. It means public confidence that the judge does not express his or her personal views, but rather the fundamental beliefs of the nation. Indeed, the judge has neither sword nor purse. All he or she has is the public confidence in them. This fact means that the public recognizes the legitimacy of the judicial decision, even if it disagrees with its contents. The precondition of public confidence runs the risk of being misunderstood. The need to ensure public confidence does not mean the need to ensure popularity. Public confidence does not mean following popular trends or public opinion polls. Public confidence does not mean accountability to the public in the way that the executive and the legislative branch are accountable. Public confidence does not mean pleasing the public. Public confidence does not mean ruling contrary to the law or contrary to the judge's conscience to bring about a result that the public desires. On the contrary, public confidence means ruling according to the law and according to the judge's conscience, whether the attitude of the public may be. Public confidence means giving expression to history, not to hysteria. Public confidence is ensured by the recognition that the judge is not doing justice that the judge is doing justice within the framework of law. Judges must act inside and outside the court in a manner that preserves public confidence in them. They must understand that judging is not merely a job, but a way of life. It is a way of life that does not include the pursuit of material wealth or publicity. It is a way of life based on spiritual wealth. It is a way of life that includes an objective and impartial search for the truth. It is not fiat but reason, not mastery but modesty, not strength but compassion, not richness but reputation, not an attempt to please everyone, but a firm insistence on values and principles, not surrender to or compromise with interest groups, but insisting on upholding the law, not making decisions according to temporary whims, but progressing consistently on the basis of deeply held belief and fundamental values. Admittedly, judging is a way of life that involves some degree of seclusion, abstaining from social and political struggle, restrictions on the freedom of expression and the freedom of response, and a large amount of isolation and internalization. But judging is emphatically not a way of life that involves a withdrawal from society. There should be no wall between the judge and the society in which he judges. The judge is part of the people. What are the means a judge can use in order to fulfill his or her role? What are their tools? Of course, the means of realizing judicial role must be legitimate. The principle of the rule of law applies first and foremost to the judges themselves, who do not share the legislative freedom of creating new tools. The bricks which we build our structures are limited. Our power to realize our role depends on our ability to design new structures with the same old bricks, or to create, sometimes, new bricks. Sometimes we succeed in creating new tools. Here the genius of the law is evident. But such inventions are few. Usually we return to the old tools and use them to resolve new situations. Here are some examples. Our main tool is, of course, interpretation. Rules of interpretation are judge-made rules. We should shape our rules of interpretation in such a way that will allow us to fulfill our role. Indeed, the bridging of the gap between law and life and the protection of the Constitution and democracy is not just the outcome of an interpretive theory. It is the underlying goal of interpretation itself. We judges should shape our interpretation rules so as to achieve the twofold goals imposed on us. Judges are creators of the common law. In developing the common law, judges should bridge the gap between law and life and protect the Constitution and its values. This is the theory of the common law in a nutshell. It is how it is integrated in law as primary limb of the body politic. The common law, like judicial interpretation, is a primary tool in the realization of judicial role. It is a very important tool. Its potential to change and rejuvenate facilitates law's adoption to the changing social needs. Its characteristic sensitivity to fundamental values and fundamental perspective guarantees appropriate protection for the Constitution and its values. A very important tool for a judge to realize his or her role is balancing and weighing. Balancing and weighing themselves metaphors reflect the need to decide a conflict between values and principles that are accepted in the legal system. The concept of balancing recognizes that the fundamental principles may conflict with one another, and that the proper resolution of this conflict lies not in the elimination of the inferior value, but in determining the proper boundary between the conflicting values. Similarly, the concept of balance reflects the recognition that fundamental principles have weight, and that it is possible to classify them according to their relative social importance. The act of weighing is merely a normative act designed to give the principles their proper place in law. Another tool that judges use to fulfill their role in a democracy is determining justiciability. That is, judges identify those issues about which they ought not to make a decision, leaving that decision to other branches of the state. The more non-justiciability is expended, the less opportunity judges have for bridging law and society and for protecting the Constitution and democracy. Given these consequences, I regarded the doctrine of non-justiciability or political question with considerable awareness. I prefer to examine an argument on its merits. In many cases, where some of my colleagues have dismissed claims on the ground of non-justiciability, I dismissed them on the ground that the disputed action was legal and therefore that the claim should be dismissed on the merits because of lack of cause of action. The court should not abdicate its role in a democracy merely because it is uncomfortable or fears tension with other branches of the state. These tensions not only fail to justify dismissing the claim, but is even desirable on occasion. It is because of this tension that the freedom of the individual is guaranteed. Lastly, an important tool judges use is in order to fulfill their role in a democracy is shaping the rules of standing. These are the rules by which the judge decides who can apply to the court in a public law complaint. The issue of standing appears to many to be marginal in public law. This is certainly the case if one adopts a view that the only person who can bring an action is someone who was a right or was injured. But if we liberalize the test for standing, we will usher in a new era of judicial decision-making, whose ramifications are far greater than the issue of standing itself. This is the case because liberal rules of standing enable the court to hear matters that ordinarily would not find their way before the court. How a judge applies the rule of standing is a litmus test for determining his or her approach to the judicial role. A judge who regards his judicial role as bridging the gap between law and society and protecting democracy will tend to expand the rules of standing. It follows that I favor expanding the rules of standing and releasing them from the requirement of any injury in fact. And I must say the Supreme Court of Israel adopted this approach. Terrorism. creates much tension between the essential components of democracy. One pillar of democracy, the rule of the people through its elected representative, may encourage taking all steps effective in fighting terrorism, even if they are harmful to human rights. The other pillar of democracy may encourage protection of rights of every individual, including the terrorist, even at cost of undermining the fight against terrorism. We, judges in modern democracies, are responsible for protecting democracy, both from the terrorism and from the means the state wants to use to fight terrorism. Of course, matters of daily life constantly test judges' ability to protect democracy, but judges meet their supreme test in situations of terror. The protection of every individual's human right is much more fundamental duty in times of terrorism than in times of peace and security. If we fail in our role in times of terrorism, we will be unable to fulfill our role in time of peace and security. In my last case, dealing with terror, I wrote, and I would like to make quite a lengthy citation because it tells not only my views, but I hope the law in Israel by now. The basic law, it's our constitution, do not recognize two sets of laws, one that applies in time of peace and the other that applies in time of war. Indeed, the Israeli constitutional law has a consistent approach to human rights in periods of relative calm and in periods of increased fighting. We do not recognize a clear distinction between the two. We do not have a balancing formula that are unique to times of war. Naturally, human rights are not absolute. They can be restricted in times of peace and in times of war. I do not have a right to shout fire in a theater full of spectators. War is like a barrel full of explosive next to the source of fire. In times of war, the likelihood that damage will occur to the public interest increases, and the strength of the harm to the public interest increases. And so the restrictions of the right becomes possible within the framework of the existing criteria. Indeed, we do not have two sets of laws or balances, one for peaceful time and the other for time of terror. There's no possibility of making a clear distinction between the status of human rights in times of war and the status in times of peace. The dividing line between war and peace is a fine one. This is the case everywhere. It is certainly the case in Israel. There's no possibility of maintaining it over time. We must treat human rights seriously, both in times of war and in times of peace. We must free ourselves from the naive belief that when terror ends, we will be able to put the clock back. Indeed, if we fail in our task in times of war and terror, we will not be able to carry out our task properly in times of peace and calm. Thus, we see that there is only one track within which framework the petitions before us should be examined. This track is, with regard to any claim against the constitutionality of a statute, the track of the basic laws. Within the framework of this track, we should follow the well-trodden path of examining the constitutionality of the law. There is no parallel track. There is no alternative route. There is one path that applies at all times. It applies in times of peace. It applies in time of war. The end of citation. Democracy ensures us, as judges, independence. It strengthens us against the fluctuations of public opinion. The real test of this independence comes in situations of terror. Precisely in these times, we judges must hold fast to fundamental principles and values. We must embrace our supreme responsibility to protect democracy and the Constitution. Admittedly, the struggle against terrorism turns our democracy into a defensive democracy. or a militant democracy. Nonetheless, this defense and this fight must not deprive our regime of its democratic character. Defensive democracy, yes. Uncontrolled democracy, no. The judge in a modern democracy must act in this spirit. I tried to summarize some, very shortly I think, aspects of my judicial philosophy as to the role of a judge in a democracy. I do realize that such a philosophy has its critics. It may and does sharpen the natural tensions between the judiciary and the other two branches of government. It may affect the confidence of the public in the judiciary. It may be labeled as activist in some aspects. It clearly has its disadvantages. It may not fit some democracies. It may not fit us in years to come. I do, however, believe that it is the proper judicial philosophy for our democracy in our times. One should not forget that a large part of Israeli population immigrated to Israel from the Near East or Eastern Europe, places where there are no democratic traditions. Democracy is just young in Israel. Because of English influences, many view democracy in formal terms. Parliament for them is omnipotence. Further, for a variety of reasons, the concept of "it is not done" is not a central part of governing in Israel. Israel lacks a rigid constitutional framework. Basic structures and concepts can be changed by a bare majority. The protection of those structures and the concepts needs judges who see their role as protectors of our constitution and democracy. Human rights in Israel was until 1992 largely the creation of the courts. Since 1992, they are embodied in two basic laws. The Supreme Court interpreted those basic laws to mean that the courts have review power of constitutionality of those laws. The Parliament and the executive branch are following this decision. In order to properly fulfill such power, one needs a judicial philosophy that views the protection of human rights as a major role for judges. Such philosophy is especially important when a country is under security risks. The political non-accountability of Israeli judges make us fit to protect human rights against excessive demands of security.